The letter arrived on a Tuesday morning, tucked neatly into my mailbox like it belonged there. Cream-colored envelope. HOA letterhead. My name spelled wrong, as usual. I almost tossed it straight into the trash. HOA mail had become background noise ever since I bought this place. But then I saw the number. $5,000. Not a warning. Not a discussion request. A straight-up fine. The violation? Unauthorized fence installation. I stood there staring at my own fence, the same wooden fence that had been there before the HOA even existed. Weathered planks. Old iron nails. A fence so old my county assessor's photos showed it in black and white. I read the letter twice, then a third time. According to the HOA president, Elaine Whitmore, my fence was non-compliant with updated community aesthetic standards and reduced neighborhood harmony. Because of that, I had exactly 14 days to either remove it or pay the fine. Failure to comply would result in escalating penalties and legal remedies. I laughed. Out loud. Here's the part Elaine didn't seem to understand. I wasn't part of the HOA. My property predated the subdivision by decades. It sat on a separate parcel, with its own access, its own tax ID, and, most importantly, no HOA covenants attached. I'd verified that with a real estate attorney before closing. But Elaine didn't care about facts. Elaine cared about control. 2 days later, she showed up in person. White SUV. HOA decals. Clipboard clutched like a weapon. She didn't knock. She rang the bell and immediately started talking through the door. Sir, this is your final courtesy notice. Courtesy. I opened the door halfway. She looked past me, straight at the fence, lips tight. That fence violates community code, she said. You've ignored our letters. Now the fine stands. I don't belong to your HOA. I replied calmly. She smiled. The kind of smile people use when they think you're stupid. Everyone here belongs, she said. And everyone pays. That was the moment I knew this wasn't about a fence. It was about power. I told her, politely, that she was mistaken. That my land wasn't subject to HOA authority. That I'd be happy to have her attorney speak with mine. Her smile vanished. Instead, she leaned closer and lowered her voice. You should be careful, she said. We've taken homes over less. Then she handed me a second notice, this one stamped delinquent, and walked back to her SUV like she'd just won. That night, I pulled every document I had. Deeds. Surveys. Title history. County plats going back nearly 70 years. And that's when I found it. A quiet clause buried in a 1958 land division, something Elaine and the HOA had completely overlooked. Not only was my property outside their jurisdiction, the HOA president's mansion sat partially on land tied to an unresolved easement dispute. An easement that traced back to my parcel. An easement that had never been legally extinguished. An easement that, if enforced, could legally strip her of ownership rights over a massive portion of her estate. The fence wasn't the problem. It was the key. Elaine thought she'd cornered me with a fine. What she'd actually done was hand me her mansion. Elaine didn't wait 14 days. She waited 4. On Friday morning, a black sedan rolled up my driveway alongside a tow truck and a man in a suit carrying a leather folder. I watched from the porch as they walked up like they owned the place. Mr. Harris? The man asked. I'm here on behalf of the Whitmore Community Association. I corrected him immediately. You're on private property. And there is no association authority here. He didn't flinch. According to our records, he said, opening the folder, you're delinquent on HOA assessments and fines totaling $5,000 plus administrative fees. The association is exercising its right to place a lien on this property. That's when Elaine stepped out of the sedan. Sunglasses on. Chin high. Smiling. She didn't say hello. She didn't even look at me at first. Instead, she looked at the house, my house, like she was already imagining it with her furniture inside. You had your chance, she said. Now it's official. I told her again, slowly, clearly, that she had no jurisdiction. That my land wasn't part of her HOA. That filing a lien would be fraudulent. She waved her hand dismissively. Every homeowner says that at first. The man in the suit slid a document toward me. It was already notarized, already stamped, already scheduled for county filing that afternoon. That's when I realized something important. Elaine hadn't made a mistake. She was counting on intimidation. Most people panic when they hear words like lien, foreclosure, seizure. Most people don't know property law. Most people fold. She expected me to fold. Instead, I smiled. You might want to slow down, I said. Because if you file that, it becomes evidence. Her smile cracked for half a second. Evidence of what? She snapped. Of attempted property seizure without legal standing. That's when her tone changed. She stepped closer, lowered her voice again, just like before. You don't win these fights, she said. We have attorneys on retainer. We have judges in our neighborhood. We've taken homes. Nice ones. Then she straightened up and turned to the man in the suit. File it. They left 20 minutes later. By noon, my phone started buzzing. A county clerk called to confirm details. A title company left a voicemail asking for clarification. Then my attorney called, and he was laughing. Do not worry, he said. At all. Apparently, Elaine's filing had already triggered a review because the parcel numbers didn't align. The HOA's legal description overlapped an old recorded easement corridor, one that hadn't been referenced in decades. The same easement I discovered the night before. Here's what Elaine didn't know. Her mansion, the one with the private driveway, guest house, and pool, sat directly over that corridor. Not a corner. Not a fence line. The heart of it. Which meant something terrifying for her. If she tried to enforce HOA authority over my land, she'd reopen the easement's enforceability over hers. And unlike HOA rules, easements don't care about power or titles. They care about records. By evening, I had surveyors scheduled. By morning, I had a legal filing drafted. Elaine thought she was foreclosing on me. What she'd actually done was invite the county to look very closely at how she owned her mansion in the first place. And once the county looks, there's no undo. The survey trucks arrived at 7:12 a.m. 2 white pickups. County markings on the doors. Orange vests. Tripods. Steel rods. Clipboards. I made coffee and watched from my porch as they unloaded equipment with the calm confidence of people who already knew something important. Because they did. By 8 a.m., bright pink survey flags were going into the ground. Not on my land. On Elaine's. Right across her pristine lawn. Down the edge of her circular driveway. Straight through the side yard she used for garden parties and board mixers. That's when the screaming started. Elaine came storming out of her front door in slippers and a silk robe, phone already pressed to her ear. You can't do this, she yelled at the lead surveyor. This is private property. He didn't even look up. County authorized survey, he said evenly. Recorded easement verification. She spun toward my house like she'd just realized I existed again. You did this, she shrieked. You are trespassing by proxy. I stepped off my porch slowly. No, I said. I'm enforcing a recorded right. She marched toward me, fury boiling over. That easement is obsolete, she snapped. It hasn't been used in 60 years. Unused doesn't mean extinguished, I replied. Especially when it was never legally abandoned. Her face drained of color. Because now she remembered. That corridor had been created decades ago for municipal access, utilities, water flow control, emergency ingress. When the neighborhood was built, developers quietly ignored it. Houses went up. Driveways poured. Pools dug. And nobody challenged it. Until now. Elaine pointed at the surveyor hammering a steel stake into the ground near her driveway. That line cuts through my garage, she whispered. Yes, the surveyor said calmly. It does. Her garage. Her guest house. Part of her driveway. Even the edge of her pool deck. All sitting squarely inside a corridor she did not have exclusive rights to. Elaine's voice dropped into something desperate. You can't just take this back. I'm not taking anything, I said. You're the one who tried to seize property you didn't control. This is just consequences. She pulled out her phone and started calling people. Attorneys. Board members. Someone she referred to as the judge on Oak Ridge. None of them showed up. By noon, the survey was complete. Red flags marked every crossing point. Spray paint outlined the easement path like a crime scene. Photos were taken. GPS points logged. County records updated. At 2:17 p.m., a county official knocked on Elaine's door. I couldn't hear everything, but I heard the part that mattered. Ma'am, until this is resolved, you are restricted from modifying or obstructing this corridor. Her voice cracked. My garage is on it. Yes, he said. That's going to be an issue. She finally looked at me, not with anger this time, but fear. You wouldn't, she said softly. You wouldn't actually use it. I met her eyes. You taught me how power works, I said. I'm just following your example. By sunset, her HOA board chat had gone silent. By nightfall, her attorney requested an emergency meeting. And by morning, Elaine would learn the final truth about easements. They don't need permission. They don't expire quietly. And once activated, they don't stop. Elaine's attorney called at 9:03 a.m. Not her usual one, the aggressive guy who liked threatening letters and bolded fonts, but a quieter firm from downtown. The kind that spoke softly and billed loudly. He didn't waste time. Mr. Carter, he said, my client is prepared to resolve this matter amicably. I almost laughed. Amicably, I repeated. After a $5,000 fine, a lien threat, and an attempted foreclosure notice? He cleared his throat. She acted within her authority as HOA president. No, I said. She acted beyond it. Repeatedly. Silence. Then, what would it take to release the easement? There it was. They wanted me to give up the only leverage that mattered. I don't own the easement, I replied. The county does. I just activated it. Another pause, longer this time. That complicates things, he admitted. Elaine must have been pacing beside him, because I could hear her voice in the background, sharp, frantic, breaking through the speaker. Offer him money. Just make it go away. I leaned back in my chair. You fine me over 6 inches of fence, I said calmly. You rejected my appeal. You laughed at my survey. Now your mansion is on the wrong side of the law. Her attorney tried again. She's willing to waive all fines. Refund your legal costs. Issue a public apology at the next board meeting. Too late, I said. The board already voted me in. That landed hard. What? Elaine snapped. Yes, I continued. Turns out once your violations surfaced, your emergency executive powers were reviewed. Improper notices. Selective enforcement. Conflict of interest. I didn't even have to embellish. The county investigation had triggered an HOA audit. That audit triggered a special election. And Elaine, who'd spent years silencing dissent, had finally given everyone else a reason to speak. She's no longer HOA president, her attorney said quietly. Elaine's voice cracked. You can't do this to me. I didn't, I replied. You did it to yourself. Then came the final offer. She would deed over a portion of her property, enough to realign the easement away from her structures. Quietly. No court. No demolition. No press. It was generous. It was tempting. And it would have saved her mansion. I said no. Why? The attorney asked, exasperated. Because this isn't about land, I said. It's about precedent. Elaine had ruled through fear, using fines to punish, rules to control, and authority she didn't actually possess. If I backed down now, she'd survive bruised and do it again to someone else. The attorney sighed. Then we'll see you in court. No, I said gently. You'll see the county first. By afternoon, formal notices were posted. Non-conforming structures. Encroachment. Mandatory remediation. Her guest garage? Non-compliant. Her driveway extension? Encroaching. Her pool deck? Obstructing a recorded corridor. Each item came with deadlines. Each deadline came with penalties. Elaine didn't scream this time. She just sat on her front steps, staring at the pink flags cutting through her perfect lawn like scars. As I walked back to my house, she finally spoke. "All this," she whispered, "over a fence?" I stopped and turned. "No," I said. "Over abuse." That night, the HOA group chat lit up again. But this time, it wasn't on her terms. The dissolution became official on a quiet Tuesday morning. No speeches. No ceremony. Just a stamped document filed to the county office stating that the association known as Willow Ridge HOA no longer existed as a legal entity. 60 years of assumed authority ended with a single signature and a date. For many homeowners, it didn't feel real at first. Then the letters started arriving. Liens were formally released. Credit agencies received corrections. Refund checks followed, some small, some life-changing. One couple received enough back to finally replace their leaking roof. Another homeowner used her refund to pay off a medical bill that had haunted her for years. Alex declined interviews. When reporters called, he said the same thing every time. This wasn't about revenge. It was about the truth. But consequences still came. The independent auditor referred her findings to the state. That triggered a separate investigation into misuse of funds and unlawful enforcement. Former board members were contacted for depositions. Insurance carriers began asking uncomfortable questions about liability coverage. Linda resurfaced briefly through an attorney. She attempted to distance herself from decisions made collectively by the board. But emails told a different story. Directives. Threats. Fine approvals signed with her name. The loophole Alex found didn't just dismantle an HOA. It stripped away plausible deniability. One by one, the people who had enforced rules without authority realized something sobering. Power doesn't protect you when it's built on nothing. Months later, the neighborhood felt different. Not perfect, but lighter. Kids played in yards without worrying about violation notices. Homeowners painted doors colors they actually liked. People waved again, talked again, laughed again. Alex stayed. He didn't run for anything. Didn't lead a new association. Didn't position himself as a hero. When someone asked him why he went so far over a $5,000 fine, he gave a quiet answer. Because it was never about the money. It was about being told to stand down when I was right. The 60-year-old loophole had always been there. It waded through decades of silence, intimidation, and compliance, until someone with the patience to read, the courage to question, and the resolve to push back finally found it. And when that happened, an entire system built on assumption collapsed under its own weight. Not with a bang, but with the sound of paperwork being filed, and power being returned to the people who should have had it all along.